Good day, Britain. You know your justice system has become an absolute farce when an Islamist terrorist who murdered 2 teenagers execution style held a prison officer hostage whilst demanding the release of hate preacher Abu Qatada, and asked to associate with Lee Rigby's killers is handed nearly £250,000 of taxpayer money because being separated from other murderers allegedly breached his right to a private life under the European Convention on Human Rights. Fuad Awale, serving a life sentence for shooting 2 people in the head in what a judge called a planned execution, has been awarded £7,500 in compensation plus a £234,000 legal bill, all courtesy of British taxpayers, because Justice Secretary David Lammy decided not to appeal a ruling that keeping this terrorist away from other dangerous inmates somehow violated his human rights. Quick favor before we explore this monument to justice system insanity. If you're furious that terrorists are being paid compensation whilst victims get nothing, hit that subscribe button right now. Over 94% of you watching haven't subscribed yet. It's completely free, takes a second, and helps us keep exposing politicians who prioritize human rights conventions over basic justice and common sense. Smash that notification bell so you never miss when we document the next ECHR outrage or judicial absurdity. If you've just subscribed, you're brilliant. Cheers. Now, let's dissect how Britain pays terrorists to be inconvenienced in prison. Shadow Justice Secretary Robert Jenrick is calling this one of the most shameful acts by a minister in recent times, demanding to know why Lammy didn't appeal the decision, why he didn't bring forward emergency legislation to prevent such payments, and why he's putting ECHR membership above the safety of officers and the interests of the British people. This is a story of how human rights law has been twisted so perversely that terrorists can literally profit from their imprisonment, why Lammy's refusal to fight this judgment reveals Labour's priorities, and how the ECHR continues enabling outcomes so grotesque they make ordinary Britons blood boil. Let's start with who Fuad Awale actually is, because context matters enormously. This isn't someone in prison for minor offences or questionable convictions. Awale is serving a life sentence for murdering 2 teenagers, Mohammed Abdi Farah and Amin Ahmed Ismail, whom he shot in the head in an alleyway in Milton Keynes Fishermead Estate in May 2011 over a drugs dispute. A judge described this as a planned execution. Awale was sentenced to a minimum of 38 years in prison in January 2013. This is premeditated double murder of young people, not some unfortunate accident or crime of passion, but calculated killing. But Awale didn't stop there. In 2013, just days after British Army soldier Lee Rigby was murdered by Islamist terrorists Michael Adebolajo and Michael Adebowale in Woolwich, Awale took a prison officer hostage and threatened to kill him unless Britain released hate preacher Abu Qatada. He pointed a sharp implement at the throat of the officer, who was pinned to a chair, and said, "Stop struggling. I've killed 2 people. I'll kill you." Think about what that reveals. Awale used the murder of a British soldier as inspiration or opportunity to take a prison officer hostage and demand the release of an extremist cleric. This isn't just a criminal. This is an ideologically motivated terrorist who poses ongoing threat even from inside prison. Following these incidents, Awale was moved to a special separation unit. Prison authorities decided that keeping him isolated from other inmates was necessary for security reasons. And understandably so, given that he demonstrated willingness to take hostages and make terrorist demands. But Awale's lawyers argued desegregation breached his right to a private life under Article 8 of the European Convention on Human Rights, claiming he suffered severe depression from being denied contact with other inmates. A judge agreed, ruling that the degree of interference with the claimant's private life which has resulted from his removal from association has been of some significance and duration. Let's pause to appreciate the absurdity. A terrorist who murdered 2 people, took a prison officer hostage, and threatened to kill him is claiming that being kept away from other dangerous criminals violates his human rights. And a British court agreed. The court was told Awale had been held in HMP Woodhill since 2021 and had not associated with any other prisoner since March 17, 2023, spending as little as 1 hour a day outside his cell. His lawyers argued decisions to deny association were opaque. He'd been denied the chance to argue his case, and prison managers failed to regularly review his segregated conditions as required by law. Now, there's legitimate debate about prison conditions and whether solitary confinement or extended isolation constitutes cruel punishment. But context matters. This isn't someone in prison for minor offenses being kept in isolation arbitrarily. This is a terrorist who's proven dangerous even in custody, being kept separate for security reasons. The ECHR court heard that following his isolation, Awale had asked to associate with one of Lee Rigby's killers, but was denied owing to counter-terrorism concerns. Think about that. He specifically wanted to associate with someone who murdered a British soldier, and prison authorities quite reasonably said no. And that refusal is now being treated as a human rights violation worthy of compensation. Justice Secretary David Lammy agreed to pay £7,500 in compensation and foot a £234,000 legal bill. That's a total of £241,500 of taxpayer money going to a terrorist. Lammy described the £7,500 compensation as a modest proportion of the overall settlement, which is true mathematically but misses the point entirely. The legal costs of £234,000 are astronomical and represent years of litigation that Lammy could have ended by appealing the decision or bringing forward emergency legislation. Lammy's letter to Robert Jenrick explaining the fees said it had been contested by the Ministry of Justice, as was the case with all litigation by prisoners convicted of terrorist offences. But clearly that contestation was inadequate because they lost. And after losing, Lammy chose not to appeal. That's a critical decision that Jenrick is attacking. When you get a judgment this perverse, this contrary to common sense and public interest, you appeal. A review by terror watchdog Jonathan Hall KC is currently being assessed which, alongside recommending an appeal into the Awale ruling, would look at how security could be improved after an alleged knife attack on 3 prison officers by Manchester Arena bomb plotter Hashim Abdi. So not only is Awale demanding compensation for being kept separate, but another terrorist has allegedly attacked 3 prison officers with a knife, demonstrating precisely why keeping dangerous terrorists isolated is necessary for officer safety. And yet the ECHR framework treats separation as human rights violation rather than reasonable security measure. The Lords, for all their ermine robes and arcane procedures, do occasionally serve as a useful check on government overreach, and abolishing a cornerstone of British justice would definitely qualify. If Turner is right, and this rebellion continues growing, Lammy's plan could become the first major legislative defeat for this Labour government. That would be absolutely humiliating, particularly on something the Foreign Secretary has personally championed. Meanwhile, the Conservatives are having an absolute field day with this whole debacle. Robert Jenrick, former immigration minister and prominent Tory, has led the charge against Lammy's proposals with accusations that are genuinely devastating. Jenrick claims that Keir Starmer and David Lammy believe ordinary people are too stupid to sit on juries and oversee justice. That's an absolutely brutal line of attack, and it's remarkably effective because it cuts right to the heart of what jury trials represent. They are not just about legal procedure. They are about democratic participation, about trusting citizens to weigh evidence and reach verdicts, about ensuring justice isn't solely administered by elites in wigs. Jenrick argues that if Lammy's proposals pass, it's the beginning of the end for jury trials. He is framing this as a slippery slope, and honestly, it's hard to argue against that logic. If you abolish jury trials for most crimes now, what stops future governments expanding that further? What prevents gradual erosion until jury trials exist only in theory rather than practice? Jenrick also points out something rather inconvenient for Lammy. If the Foreign Secretary was genuinely interested in tackling court backlogs, he would get courts sitting around the clock. Extended hours, weekend sessions, properly funded court services. But Lammy refuses to pursue that option. Even more damningly, Lammy himself has apparently confessed that slashing jury trials won't even guarantee the backlog falls. So we're abolishing a fundamental democratic right for a policy that might not even achieve its stated objective. Brilliant. Absolutely brilliant. Jenrick's conclusion is savage. The truth is that many in the Labour Party simply don't trust ordinary people to make decisions. The message from Starmer is clear. Ordinary people are too stupid, too troublesome, too time-consuming to be trusted with administering justice. Whether you agree with Jenrick's politics or not, you have to admit that's an absolutely devastating critique. It positions Labour as elitist, condescending, and fundamentally distrustful of the very people they claim to represent. That's a kind of political framing that sticks, that gets repeated, that forms a basis of effective opposition messaging for months or years. Let us talk about what this rebellion actually means for Labour's stability. This isn't some obscure policy disagreement about agricultural subsidies or technical amendments to planning regulations. This is a fight over fundamental principles of British justice, democracy, and trust in ordinary citizens. When 35 MPs are willing to publicly oppose their own government on something this significant, that's a massive red flag about party unity. When the former Deputy Prime Minister is making representations behind the scenes against government policy that suggests serious fractures at the highest levels of Labour. Jury trials have been a cornerstone of English law since the Magna Carta in 1215. That's over 800 years of legal tradition, of citizens participating directly in the administration of justice, of the principle that your peers should judge you rather than solely legal professionals appointed by the state. Yes, the system has evolved considerably since 1215, but the core principle remains remarkably consistent. Ordinary people, randomly selected from the community, hear evidence and determine guilt or innocence. It's democracy in its most direct form, applied to the justice system. The arguments for maintaining jury trials are compelling. They provide legitimacy to verdicts in a way that judge-only trials simply cannot match. When 12 citizens unanimously or by majority agree on a verdict that represent community consensus about guilt or innocence, they act as a check on state power, ensuring the prosecution must convince ordinary people, not just legal professionals who might have institutional biases. They bring diverse perspectives, life experiences, and common sense to legal proceedings. A jury might spot inconsistencies in testimony or recognize implausible scenarios that a judge, immersed in legal technicalities, might overlook. The argument against them, which Lammy presumably subscribed to, focus on efficiency and cost. Jury trials take longer, cost more, require coordinating 12 people's schedules, and occasionally produce verdicts that legal professionals find baffling. Court backlogs have reached crisis levels, with cases delayed for years, victims waiting endlessly for justice, and defendants left in legal limbo. Something needs to change, the argument goes, and jury trials are an obvious target for reform.